any form of communication, at least visually, can border on the exaggerated, more or less what I call propaganda. Thank you.
So one more, and then I'm going to turn back to the panel to not totally overwhelm you with questions.
Okay, I'll make it quick. So my question would be accountability. Now, because we talked already in the morning about, okay, like different type of images that we're being created. And of course, I can understand that, people want to create their own images, or NGOs, of course, have a different mission and a different agenda to create images. But what about the role of lawyers in that sense, and especially going back to Federica's talk in that sense, when we as lawyers or legal scholars in that sense, or courts or international organizations create this type of imagery that we know from the NGO field in that sense, what kind of accountability standards do we have right now? Because I really wonder if there are any, and in that sense, whether we would need some in that sense because we play with emotions. We use different tools that we hadn't had in the past. So do you think this type of ecocide imagery that for example, you looked at from an NGO perspective, if that would be now adapted by, I don't know, legal scholars or by legal courts in that sense, that would make a difference? And for you, how would I measure this difference? The same, of course, with borders. No, it's one thing what Frontex, for example, puts on its Twitter, like it's sometimes really maddening, no? Like we're saving the world by kicking people back. But yeah, thank you. Sorry.
Nothing to be sorry about. Thank you. So I would like to start with Andre and then move across the panel. And if you can keep it to about 2 minutes each, that would be wonderful. And obviously, take what you like, ignore the rest. No, try to answer all the questions. I think they're really fruitful.
Yes. No, thank you, Moshi, for the question. In fact, what I meant to say is that they are indeed, there's often an association between, especially when we talk about it in international environmental law, between indigenous people's representation and their relationship to nature, right? And what I meant to say is precisely that we should not just assume that there is a direct relationship, because as many would say, it's about indigenous people's rights, not necessarily only about environmental law itself. So the modes of existence, the ways in which the performances in the process of instauration actually reveal these modes of existence, they are very much different. The case in the Inter-American Court of Human Rights, that was a way in which, say, the Shukuru found a different process of representing and actually constructing, so to say, the aesthetical and normative content of their argument without actually having to take recourse to, say, property law in Brazil or competitive law in that case, for instance. So that's basically what I meant to say. I think that's about
it. Thank you for the questions. I think they're very interesting and makes me think. I'm not as for the first question, I'm not very experienced in the concept of aesthetics. But what I can say from the perspective of border studies, there's an emerging understanding of border aesthetics, for example. And on that basis, actually, it reflects on how people or those who experience the borders reflect on their own experiences. And I'm not sure if I idealize or if I'm idolizing the concept of aesthetics in my own work. But I can say that I'm mostly focusing on those who are experiencing and reflect on their own experiences from my own perspective. And that's kind of what I can say about that. And in terms of the drawings and narratives, if they're exaggerated, I think, we can see exaggeration in all types of narratives and in all types of artworks. And because mainly because narratives are not, or imagery, they're not kind of the simple windows to the truth itself. And we cannot seek a real meaning or the actual meaning behind those kind of imagery or the narratives, but we can interpret them based on our own background. As I also said in the presentation, we can kind of reflect on our own understanding of this imagery and unpack some narratives based on our own kind of experience and environment and background. And we can also supplement these interpretation with other sources of knowledge to kind of unpack our own understanding and our own meaning making behind these narratives. So, yeah.
Thanks. Since well, we moved this order, maybe I'll go ahead then. I'll take the fair enough. I'll take the question about accountability because I find it really interesting. So, a couple of thoughts about this. First of all, I mean, accountability for what? I mean, for kind of the political effects that these images engender, or yeah, I mean, fair enough. So that would be the first question, like for what exactly are these NGOs accountable? Then what you mentioned about, okay, if this was a legal actor or a court, I do agree that there would likely be a heightened level of accountability, merely because of the public status and institutional mandate of these actors. So they have a different mandate than an NGO. And so I think the question of accountability in the case of the NGO would be leading back to, well, is it effective? Because in the end, sort of what NGOs do is strategic advocacy. And in this sense, one might say, well, if these are the images that are effective, and there are studies that say, you know, cute polar bears, megafauna, etc., are very effective in like getting people involved and rallying support, well, then in that sense, there might not be so much of an accountability issue. Of course, I think there's another dimension of accountability here, which is sort of for this like reinforcing stereotypes and biases that we also mentioned. And I think here the accountability is like our project is hopefully one of accountability, right? Like for maybe I'm romanticizing here, but for academics, for scholars to hold these NGOs accountable for the type of visual contents and the narratives that they're pushing. And that I think is very much something that can and should happen. And that's also the invitation of our paper in the academic world. That's what I have to say about this, George.
Yeah, I'll pick up on that accountability point slightly. I do think that there is a bit of a sense of lawyers hiding from accountability just in this sample of images. In that, as I said, when we get to anything about ecocide as an idea, legally or in a court, suddenly it's images of wigs and gavels and scales of justice, and it's completely detached from the reality. Literally just a kind of a side-by-side picture of what's happening in nature with those images would be a real step forward, I think. The other question on sorry, Illa's kind of in the way. Can't quite see, sorry. The other question on whether these pictures kind of don't go far enough or kind of downplay the situation. They're not shocking images. And I think that's probably quite a calculated move. But yeah, maybe they could go further. I think the point where they're definitely lacking in terms of their potential as kind of artifacts of advocacy is in showing the perpetrators. We have very few images in our sample where you can see who it actually is who is causing this. What those images would look like, I don't know. But I mean, we literally had a kind of column on our Excel spreadsheet going through all of these. Yeah, so we've got one or two, but we identified whether it shows victim or perpetrator. And there were maybe, of the 68, there were about 3 or 4 that showed anything like a perpetrator. So I think there's an accountability gap there as well. But I think just on how far they go, I think that there's a question also of balancing whether the images show the scale of environmental destruction or show its intensity. So there are some images in the sample of forest fires that sort of show, a really intense, dramatic, spectacular scene, but they're very localized. You either get that or kind of helicopter imagery that's quite detached from the situation, but shows its scale. And I think getting both of those together is quite difficult. But I go back to my previous point. I think they've deliberately actually gone for quite positive imagery because it's a project that they want people to be excited about and contributing to and donating to, rather than being really kind of sinister sort of shock politics. But I think there is a role for both kinds of imagery in the visual advocacy around ecocide. It's a very long answer, but you get what I mean.
Thank you. Federica, we lost you on screen, but can you hear us?
Yes, I can. Sorry.
Yes.
Sorry.
Oh, there you are.
My face on the big screen was aesthetically not so very nice for the whole time. So super quickly to answer to the question, thank you for the suggestion. And as to your question, absolutely. This is actually a conversation I was having yesterday with a colleague, which means that there is clearly a blind spot in the way that I sort of present the arguments. I do not mean the two aesthetics as alternatives. Coming very open here, I don't think that Just Stop Oil or Ultima Generazione in Italy should stop with the protests or using these aesthetics of violence. What I mean is, if we take Bruno Latour triad of aesthetics and we come to a point where in whatever engagement with the art, we manage to transpose or make ourselves sensitive to the climate change tragedy, for example, also at the level of a political discourse, there will be a point where we need a response, hopefully, before we, extinguish ourselves. So here, the point is, what kind of response do we want? And if law doesn't have the resilience in it, I'm worried that this response is again sucked in an aesthetics of abstraction rather than an aesthetics of resilience. Whereas if we involve artists and if we have a multidisciplinary approach and if we take participation seriously, then perhaps the type of response might really bring us forward. So I do not mean those as an alternative. I think they should absolutely continue. I do hope that at some point there will be a response. And to me, the aesthetics of resilience is as the quality of the response. And again, I don't mean, I take it a bit as with Andre here, it's not about beauty or the sublime. It's really how we make ourselves sensitive to phenomena around us. So I hope that answers your questions, but thank you very much. This is something that I will have to address in the extended paper.
Well, thank you so much to all of you. And thanks for taking us back to these fundamental principles, around questions of representation and who's actually marginalized and whose agency do we see? And what does this convey? What's visible? What isn't visible? I definitely want a lot more of these to be visible. I'm really looking forward to seeing your papers in print, hopefully with lots and lots of the visuals represented in the actual papers. Very much looking forward to that. For now, I just want to thank you for all these fascinating papers, presenting them, engaging in the discussion, and I'm looking forward to more of the same. Thank you so much, and to all of you for your really fruitful contributions and questions. Thank you.
Wonderful. Yeah, we still have battery. Okay. So we had 4 fantastic sessions for the day so far. It's been a marathon. We've heard very, very stimulating presentations and papers. Now, to wrap up the day in the best way possible, it is my immense pleasure to welcome our second keynote speaker, who is connecting from Colorado, Professor Pierre Schlag. Let's see if the connection works well. Professor Schlag, can you see and hear us? Perhaps not. So let's see.
Yes, I can hear you. See you.
Wonderful. We cannot see you from this side of the screen, but let me see. Is there?
It's my fault. Here we go.
Oh, great.
Great. Now we can hear you. Well, good morning. Good morning, Pierre. So thank you for being with us today, for connecting from the other side of the pond. So Professor Schlage and I have decided that this keynote event should be more of a keynote interview or discussion. Before getting there, well, the aesthetics of academic conferences demand that I say a few words to introduce Pierre. Pierre Schlage is currently a distinguished professor at the University of Colorado and the Byron R. White Professor at the Law School. Before joining Colorado in 1989, Pierre taught at the University of Puget Sound School of Law. And if I am correct, you've also had a stint in practice, right? For a few years at Covington and Burling.
Correct.
Oh, okay. Now I'm entering your screen, so you might be able to see me. Okay, all right. But Pierre is also and fundamentally one of the most original voices in US critical legal thought. I won't say critical legal studies because I guess that might prompt a reaction. So I'm curious about that. But so Pierre's meticulous deconstruction of what he calls the American legal mind, with its rationalizing assumptions, its myths, its fetishes, its aesthetics, has, I think, inspired many others to pursue similar deconstructions in other contexts and in other fields of law, including, why not, international law. So, Pierre, once again, thank you for being with us. I'm particularly pleased that you are with us, also because several of your works engage with legal aesthetics. Some do so as their central focus. I'm thinking about your Harvard Law Review article, The Aesthetics of American Law of 2002. And some other works engage with aesthetics as part of your broader critique of the intellectual and professional universe of American lawyers. I'm thinking about your 1998 book, The Enchantment of Reason. So let me break the ice here and ask you a personal question. Why are you interested in the aesthetic of law?
Well, first, let me thank you for inviting me. I'm very honored to be here, if only by Zoom. And I'm particularly honored because I only know half about the subject of your conference, and that is aesthetics. I don't really know much about international law. So I'm particularly grateful that you invite me. In terms of why I'm interested in aesthetics, I think there are several reasons. First, I think I have experienced law, like many people, aesthetically, that some of the most marking experiences that I have had in my encounters with law can be called aesthetic. So the first day that I arrived in law school, it was 9 o'clock in the morning. I hope this works better than that first class. And I walked into a classroom that was completely sealed with no windows. The seats were anchored to the tables. I sat there. The only person who could move was the professor, and I felt deeply uncomfortable, deeply constrained. It was a very unpleasant experience. The tables were Formica. The chairs were plastic. I really didn't want to be there, and I felt this experience of terrific constraint. An experience which I then felt throughout the rest of the semester, in which the professors who were practicing a full-on Socratic method would interrogate the students, and I felt I had the sense of being trapped, which being in law as a practicing attorney, as a law professor, as a law student, this is not an unfamiliar experience, I think. And it is an aesthetic experience. It has somatic effects. And indeed, back in those days, in the 70s, this kind of experience would induce fear in the students. I guess that's more emotional than aesthetic, but the emotion of fear itself has aesthetic aspects. And so this sense of constraint made me want to escape, and escape has been an underlying aesthetic theme in my work. I experienced much the same thing as another marking experience when I started teaching, and this was in the early 80s, and I would go to the faculty lounge where I would get interrogated by my colleagues who would ask me constantly, well, Pierre, what do you think the court should do in this case? And at the beginning, I would answer the questions. But every time I went to the faculty lounge, they would always ask me, well, what should the court do? Or what should the legislature do? And again, I felt constrained, but not only constrained, but bored and annoyed. Why always this question? Why repeatedly? I'm not interested in this question because I cannot communicate to the courts. I cannot communicate to the legislatures. There is no connection. Again, I think this was an aesthetic experience. And I don't think this is unique to me. I think that a lot of law has aesthetic aspects which many legal professionals do not recognize as aesthetic. And so making the aesthetics of law, of the sites of law, the classroom, the faculty lounge, the case books, the treatises, the law offices and the like, is something that really interested me. And the second thing is that I think aesthetics are quite political. That is, the aesthetics channel what can be said, what cannot be said. They channel what can be translated into law and what cannot be translated into law. And so attention needs to be paid to the aesthetic, right? And it's really only recently, and by recently, I mean the last 20, 25 years, that aesthetics has become important in legal studies, and ever more so. I mean, it's much more important now than it was in 2000, let's say. Way back when, Carl Llewellyn, the famous US legal realist, talked about the aesthetics as being a slighted subject, and he sought to introduce aesthetics to law. But what he had in mind was a very narrow conception of aesthetics, which was craft. I, meanwhile, saw aesthetics everywhere, right? So the aesthetics of law, the way in which law is organized, and by law here, I mean a very traditional, conventional, positivist conception of law, right, is everywhere, right? So if you go to a restaurant in a mall somewhere, I mean, you'll find that there are a number of parking spaces there, right, which are required by the city or county code. There must be sufficient parking. If you enter the restaurant, the tables are a certain distance apart, and that's because of the fire code. There have to be a number of doors there. That's again because of the fire code. So law is materialized. I don't need to suggest that law is an origin here, but law is materialized all over the place. And if law is itself infernal, then we will produce infernal forms of life. So there was that. It also seemed to me that aesthetics was a way to approach the metaphysics of law. And I'd spent a fair amount of time working with Derridian deconstruction and critiques of metaphysics, reading some Nietzsche, some Heidegger. And it seems to me that these were all attempts to indeed critique metaphysics. What aesthetics promised to do for me was to allow an understanding of how metaphysics was composed. That is, it was a way not only to dissolve metaphysics, but a way to see how it was constructed in the first place.
And so, thank you so much. So if I may interject here, in your work, you have a particular construction of aesthetics. So let me maybe get this point of clarification. So your conception of aesthetics is, on the one hand, very broad, as you just mentioned. It encompasses forms, metaphors, images. But on the other hand, it's quite narrow, because what I don't read in your work is, well, it's a research that brackets art, that brackets beauty, maybe the search for beauty. So let me ask you here, why so broad and why so narrow? Why did you choose these aesthetics and not others?
So why broad? And you're right, in describing my conception of the aesthetics of law very broadly, and I would say very loosely as well, right? And part of the reason I described it so broadly, right? This is basically dramatistic tensions, tropes, metaphors, images, schemas, sensations, perceptions, etc. I was going to allow a lot in. And I did that because I didn't want to prefigure the exploration of something which was very unformalized, right? So I didn't want to set up definitions and conceptualizations. I had almost a resistance to rigor, right? I wanted to be loose about it at the beginning and then see what happened. So that was one of the reasons I wanted to be broad. Another reason was I didn't want to have to adjudicate between the importance of graphic arts, literary arts, rhetoric, etc., as to what was important to law. Or cognition, all these things. I was not in a position to adjudicate between them as to which was most important in terms of the aesthetics of law. So there was that too. That's why I was so broad. Now the part that was narrow, and by the way, I'm not, this was basically sort of setting out my project. It was not an attempt to say, well, this is what aesthetics is. There's nothing else. Art and beauty are completely foreign to the scene. It's just I didn't want to pursue these lines. Art and beauty, and this is the part that's narrow, I sort of dismissed art and beauty from the scene of my writing. Not that art and beauty are irrelevant, but the tendencies of those who had come before me, who brought in art and beauty, led to a kind of romanticization of law and an idealization of aesthetics, so that the ugly, the repulsive, the disgusting was ruled out. And of course, there's a lot to law that is ugly and disgusting and infernal, and not just. I mean, there are parts that are. I mean, you can talk about the beautifully crafted brief, but to prefigure the aesthetics of law by limiting it to analogies to art and beauty seemed to me to prejudice what it is I wanted to do. Now, I want to insist again that, this is just my projects. I don't want to say that, this is what the aesthetics of law consist of and everybody else is wrong, nor do I want to say anything about aesthetics generally.
Thank you. And let me pick up on a comment you made earlier. So one of the things that really ticked you off was your colleagues asking you what the court should decide. So you refer to this as scholarship imitating judicial discourse. And if I can quote from your article, again, The Aesthetics of American Law, then 20 years ago, you lamented a certain dearth of literature and analysis of the psychology, the institutional pressures, and the political preferences of judges. So it seems to me that these captured your dissatisfaction with formalistic reasoning about what the court should decide. So I don't know if I'm reading that correctly, but my question would be, well, 20 years later, as you mentioned, now, these dearth of literature has partly started to fill. Not only do we have political scientists, sociologists, anthropologists, cognitive psychologists hard at work on how judges really think and how do they go about their business. I think that university curricula are also a little more open to the question, are giving those questions a little bit more space. So what is your take on these developments? What has transpired in these 20 years? Is legal academia ready to renew its aesthetics? Or are we reinforcing endlessly the same aesthetic frameworks that constrain us?
So I think one of the things that has happened, and pretty much since since the 70s is that there has been at the substantive level a terrific opening up of permissible subjects, permissible topics, and it really has been very generous, very capacious as far as substance. As far as form, there's been an opening up as well, but it's not as pronounced as the opening up of substance. I do think there are now studies of subjects, the construction of the subject in law school, and that sort of thing, and that's a good thing. But there is something that remains remarkable about what I take to be the dominant image conception of law as objective, right? I think that remains largely prevalent, particularly in those fora where legal academics are not conscious or terribly conscious of what they're saying, right? I mean, so if you ask a legal academic, is law objective? A legal academic will probably give you a sophisticated response and say, well, no, we are talking about intersubjectivity now, and blah, 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 blah. But as to what they will do, they will rely on a notion of law as objective. Well, assuming that's true, and this is debatable, but assuming that's true, it seems to me that it's necessary to attend to the subject. That is the subjectivities that create law, that produce and reproduce law, and that this still remains under-investigated, right? And the problem could be put this way: if law is objective, then what is it? What is it that compels or guides or makes legal subjects adhere to this objectivity? And I don't think we have very good answers to that. Still.
You just mentioned, well, let me go back to this comment about places where people are not particularly, especially scholars, not particularly careful about what they say. So for the benefit of the audience, let me focus again on the aesthetics of American law. So in that article, you articulated 4 aesthetics that, in your view, pervade and orient the legal imagination of US lawyers, right? So there is this grid aesthetic, which makes us see the law as rigorous and well-defined object forms. The energy aesthetic, which offers a kinetic image of conflicting precedents, principles, etc. The perspectivist aesthetic, which situates the meaning of and value of laws in relation to their context and the viewpoint of the observer. And finally, what you call the dissociative aesthetic, that dissolves stable identities and reveals the radical indeterminacy of legal discourse. Now, talking about places, do you think that these aesthetics, these 4 aesthetics, are specific to American law? Do you see them as potentially extending to other legal fields? And I'm asking that as a European scholar. So when we start engaging with the law in European academia, there is this maybe trite opposition between like European positivism, formalism versus common law, and especially North American common law dynamism or kinetic image. So what are your thoughts on these? Where are these perspectives and aesthetics situated in your view?
So one of the reasons that I limited, or the reason why I limited this aesthetic to American or US law, is because that defines the jurisdiction of my competence. That is to say, like most US legal academics, I'm really quite parochial. That is, I know US law. I don't know much about the law of other nation states or international law. And so I didn't want to overclaim. At the same time, it seems to me that these aesthetics are if not ubiquitous, I would be very surprised if they were not instantiated in other legal fora, if they're not instantiated in European law. But But it might be that there are other aesthetics, and I'm sure that's the case, that I have missed, right? That are on par with the four aesthetics that I described. But those struck me as the most dominant in the United States. It may be that there are other major aesthetics that are more dominant or more visible in other countries. But I would be surprised if these aesthetics were limited to the United States. It's just that I didn't want to overclaim.
Thank you, Pierre. I was particularly intrigued as I rereading the Aesthetics of American Law was very nice in preparation for this interview. And during my second reading after many years, I was particularly intrigued by the dissociative aesthetic. So this aesthetic that collapses legal and discursive categories. You write that once you embrace the radical indeterminacy and the dissolution of legal discourse, any serious intellectual project about law becomes almost impossible, right? And I think that any self-honest lawyer has experienced at some point or another these unease, these ineffable unease of dissolution. And then as lawyers, as academics, I guess that most of us find coping mechanisms to forget about this radical indeterminacy and to go about our daily business, right? We write about law, we practice law, we interpret law. So first, how did you cope with the dissolution? So having understood and experienced the effects of dissociation, where did you find the determination to continue writing about and engaging with the law for, well, another 20 years or more?
That's a lot. So let me talk a little bit about the indeterminacy point first. I think radical indeterminacy is one of the consequences of the dissociative aesthetic. But that there are, let's say I'm going to be grid-like. Let's say there are three kinds of indeterminacy traditions in the United States. One is the indeterminacy is based on language, the vagueness of language, the insufficiency of text, the pluralistic character of context, which make the meaning of the text differ. So that's one common understanding of the sources and the character of indeterminacy, and it's probably the one that's most prevalent. There is then the original critical legal studies conception of indeterminacy, which is grounded on the sense that the legal system, the liberal legal system, is pervasively contradictory, and that indeterminacy stems from the constant encounter with contradiction within legal reasoning, within legal interpretation. And then there's this dissociative aesthetic, which is a little bit different, and it's akin to Derridian deconstruction, though it's not Derridian deconstruction, and that is the experience of things falling apart. I mean, you're dealing with a term or an expression or a concept, and you think you know what it means. For instance, a contract, you will have all sorts of documents, judicial opinions, or contracts themselves that will refer to the contract. And so it makes sense to you. You're a lawyer or you're a law professor or a law student, and you think, I know what a contract is. And then there's this moment where you have some doubt. Maybe it's because of the nature of litigation, but then there's the contract and you think, well, what is the contract? Is it the agreement between the parties? Is it the agreement that they intended? Is it the written document which memorializes one of those agreements? Is it that part of the document which is enforceable by law, as opposed to those parts of the contract that are void or voidable? I mean, so I mean, all of a sudden, this expression which goes without saying the contract, right, so sort of breaks down on you, right? And this can happen with anything. It can happen with the notion of the corporation, right? I mean, Felix Cohen did the famous U.S. legal realist did a kind of pre-Derridian deconstruction of the corporation, pointing out that the corporation is among other things a legal relation. It's not just an entity. It's not just he attacked the personification of the corporation, the thingification of the corporation, and then he talked about the corporation as a legal relation. And that was his move. And it was a really good move in 1935. But now in 2000, it's just like, well, wait a minute. A corporation is really all of those things, right? That is, if the only thing you think of as a corporation is the legal relation, right? You can't really do very much with that. If a corporation is simply a legal relation, then you don't know what a corporation is. You do have to have recourse to corporations as entities that are materialized, forms of behavior, functions in an economic system. And there you go. There's the dissociative aesthetic again. Now, I think the dissociative aesthetic, as you mentioned, is actually a common experience among lawyers, law professors, and certainly law students. I mean, in the first 2 months of law school, I think law students experience little else, frankly, except things falling apart. But the dissociative aesthetic, I think, is a common experience. It's not all bad, right? It's not this sense of loss of coherence is not all bad. I mean, for the lawyer, it's a brainstorm, possibly, right? I mean, when the idea of the contract falls apart, the lawyer in litigation can proceed to reconstruct it, focusing on this aspect or that aspect, and produce, something, the contract, that is going to be cognizable by judges in a much more familiar term, but it's been reconstituted by the lawyer. So it is a moment in legal reasoning. It is an aesthetic experience, which is part of legal reasoning, and it can have positive aspects. And the same thing, I think, is true for a law professor, right? That is a useful experience. I tend to think that if you are, and now switching entirely to the law professor, I think it's only when things fall apart for you in a big way that you can start to really explain things, try to understand things. If things have not fallen apart for you, then you don't have all that much to explain. I mean, you do have something to explain, but if you really want to undertake radical inquiries in both the political and the intellectual and the aesthetic sense, then things need to fall apart. And this is why it's a useful aesthetic. Now, the associative aesthetic is not a particularly useful way to go through life. It is, after all, named after a mental disorder. It's unlivable, right? The dissociative aesthetic, you need to step out of it. You cannot go to. I keep thinking about restaurants and food. I must be hungry. You cannot go to a restaurant and order lunch with a dissociative aesthetic. It's just not going to work. And it's not going to work except if you lay it out the way I just did, if you talk about it. But it is useful. One of the things I wanted to do in the article is to give people the experience of the dissociative aesthetic and to get people to recognize it as an aspect of law, and both a destructive as well as a constructive aspect of law. I think, as you said, a lot of people have this experience, and they want to just then put it aside and get on with their business. I think that's a possibly unfortunate tendency. I think it's a good thing to sort of become familiar with the dissociative aesthetic. And I have to say that one of the efforts that I made in the Aesthetics of American Law, the article, was to try to get the reader to experience the dissociative aesthetic. And in fact, that's part of the organization of the article. It's not just a description of various aesthetics. It is an effort through various ways to get people to experience the various aesthetics, to trigger the experience of living in a grid-like universe, or to feel the motion, the movement of law and economics, or of balancing, of proportionality, of metrics, of calculation, right? And then since I realized that the dissociative aesthetic was the most foreign one to legal thinkers, I had it last, and I was part of the point of the aesthetics of American law was to introduce the dissociative aesthetic, right? To get a reader familiar with more familiar aesthetics like the grid. I mean, who's not going to recognize the grid?
Yeah. Well, this is a fantastic segue to my next question. I'm mindful of the time, and I do want to leave to open the floor to the audience for their own question. But let me ask you, let me pick up on this notion of the reader experiencing an aesthetic. Something that always strikes me when reading your work is your subversion of the standard form of the typical law review article. So I'm citing a couple of examples for the audience's benefit. In Spam Jurisprudence from 2009, your footnotes take on a voice of their own and sometimes disagree with you. In the law review article from 2017, you fill up each section of the article by saying what that section should contain if you were writing a law review article, and so on and so forth. So there is an element where you want your reader to experience things. So 3 quick questions. First, would you agree with me calling this move subversive, and subversive of what? Second, are these instances of aesthetic resistance? Is this part of a totalizing vision of the role of the legal academic? And third, maybe more practically, so what advice would you give to more junior scholars who want to follow your example? So those scholars who want to try and do that will probably encounter some resistance from law reviews, book publishers. So a piece of advice for younger scholars wanting to experience the aesthetics also from the point of view of writing.
That's very good. So I hope it's subversive. I think it's important not to be to overclaim here. The works, the various essays do try to subvert forms of thought, but we are talking about forms of thought. We are talking principally about the legal academy. Although, I mean, lawyers occasionally read my article. I doubt any judge. Well, actually, that's not true, but we can count the judges who read my work on one hand, probably. So I think there is an effort to subvert and to undermine the forms of legal thought, right? If you think of all the forms within which you might write or speak about law, and you have let's say we have a spectrum, right? Then really the opportunities for writing are extremely limited as a matter of form, right? You have the law review article, you have the university press book, which looks a lot like a dissertation, right? Typically. And then you have the collected works. I mean, surely there are all sorts of other forms in which you can write, and I've experimented with them and I've explored some of them. And it is those forms, I think, that will allow you to say something different. And if you remain entrapped in the law review format, I mean, you are seriously constrained. You are seriously limited in terms of what it is you can and cannot say. So there's a political aspect, but I don't want to overclaim, right? The political aspect of doing this, right? It's a very modest sort of politics at work here. On the other hand, it is the kind of politics that legal academics are well positioned to practice, right? That is, they can practice a politics of knowledge that is sort of introducing the kinds of knowledges that are brought to bear on law. This is a power that legal academics have. Again, it's not the be all and end all of political change, but it is a power they have. Whereas the claim that what is really political is normative thought, making recommendations as to what should be done, I think that's not very political at all. I think that normative recommendations are not read by legal officialdom unless legal officialdom is already prepared and receptive to those politics. So yeah, I think there's a certain a small ambition to subvert the forms and to create ways of showing that you can break the forms, that you can go beyond the limited styles, forms, aesthetics of scholarly publications. So yeah, that was what I was trying to do. Now, I don't understand the resistance and the totalizing point, so maybe you can tell me more what you mean.
Well, focusing on the resistance, publishing, so as this is a mundane but I think important point, so when you try to get firm foothold in academia and you want to write and engage, I think that exploring subversive aesthetics in your writing comes at a cost, also in terms of like publication outlets. And so should we kind of avoid, so to find the right publication outlet? Should we, if we wanted to write more, let's call it creatively or dangerously, to quote Camus, should we try and push our agenda in our writing through more traditional publishers? Do you have any strategies there? I don't know if that clarifies the question.
No, that does. I mean, that's a big problem, right? I mean, because it's there is the chance that if you break form too stridently or you break form too intensely, you won't be able to publish, right? And you need to publish. Plus, you need to publish a form that is relatively standard in order to meet tenure requirements, in order to become a scholar. I mean, you need to do that. So it seems to me that you can push the envelope a little bit, and there are various ways of doing that. You know, you can have a sort of an arch way of writing and speaking that makes fun of the form in a way that is somewhat subtle. And some of my writings are not subtle at all, right? And there's I think it was possible to do that when I was a young faculty member. I think it's probably going to be possible to do that at some point, because people would just get too tired of the forms that exist. I mean, you did have, aesthetic breakthroughs at various points in history, right? You had, in the United States, there were 3 aesthetic and theoretical breakthroughs, 3 moments, I think, when law and legal thought of professors was really exciting. The first one will come as a surprise to you, but it was the moment of formation of the Langdellian legal formalists, who basically started writing treatises and case books on law. And while they would never have called themselves theorists, that's pretty much what they were doing. They were theorizing law as doctrine. After all, the United States is a common law country, and they were taking common law and transforming it into doctrine. And they came up with these treatises and these case books, and it was a new form. Then you had the legal realists in the 20s and 30s. And if you read their articles, they're very punchy. They're very short, many of them. They're very to the point. They are not belabored. They are fun to read. And by the way, that's one of the ways in which you will be allowed to break form if you write lyrically, if you write in a way that is engaging at the level of form and aesthetics. That gives you some entree into breaking form. And then there was a third moment that was really interesting, which was basically the 80s and the early 90s, and for me, particularly critical legal studies, in which again you had this kind of form that broke, right? And there was a lot of resistance to legal realism. There was a lot of resistance to critical legal studies and the interdisciplinary movements, but they were there. They emerged, and so I think something will emerge later. But my advice would be not to overdo it.
Well, thank you for concluding this part of the chat on a hopeful note. I'm looking at the audience. I know it's the late hours. We do have time for a few questions. So any questions for Pierre from the audience? I think that we might have exhausted the energy in the room. It's been a very, very long day, but no, not really. So in which case, Pierre, let me thank you, and please join me in thanking Pierre for being with us today. And well, we hope we have an opportunity to continue this conversation, but for the time being, well, have a great day and thank you very much.
Thank you. Thank you.